Brogan Stewart, Marco Pitzettu and Christopher Ringrose, you can remain seated for the moment. On the 14th of May this year, you were convicted of serious offences for which I am to sentence you today. You were all convicted of engaging in conduct in preparation for acts of terrorism. Each of you was convicted of 2 further offences of collecting information likely to be of use to a person preparing or committing an act of terrorism. In addition, you, Christopher Ringrose, were convicted of manufacturing a prohibited weapon. I'm also to sentence you, Marco Pitzettu, for possessing a prohibited weapon, a stun gun, to which you pleaded guilty approximately 6 weeks before the trial. All 3 of you adhere to an extreme right-wing ideology. I say adhere in the present tense, as it is clear to me from the pre-sentence reports prepared for each of you that that remains the case, notwithstanding your conviction of these serious offences. As Dr. Allen, an expert on hate and the extreme right wing, said during the trial, those who are within the extreme right wing do not want to work within the democratic process of this country, but to use any means necessary, including violence, to bring about change. That was, and in my view, remains your mindset. Prior to your arrest, you had never met each other, although arrangements were being made for you to do so. All of the exchanges between yourselves and sometimes with others over the 3 years with which the jury were concerned were on the internet. Your thoughts, beliefs, and on occasion actions were all laid bare in a timeline prepared by the prosecution, which formed the lion's share of the evidence at trial. The timeline ran to 374 pages. Those pages were filled with hate towards black and other non-white races, especially Muslim people and immigrants, with ideas of white supremacy and racial purity, together with a belief that there must soon be a race war between the white race on the one hand and other races on the other, with anti-government rhetoric, and with the glorification and admiration of the policies and actions of Hitler and the German Nazi Party, including anti-Semitism, and of mass killers who had targeted black or Muslim communities. I do not propose to rehearse the timeline in the course of these sentencing remarks. In summary, in the posts up to the end of 2023, you shared your derogatory views about non-white races and the need to use violence against them, and on occasions, the need to kill them. For example, you, Brogan Stewart, saying you wanted to put Muslims down for a forever nap. You shared extreme right-wing ideological texts and material, such as the recording made by Brendan Tarrant when he killed 51 innocent people in attacks on mosques in New Zealand in 2019, posted at different times by you, Marco Pitzettu, and you, Christopher Ringrose. You shared information on the manufacture and use of firearms, ammunition, and explosives, including the documents contained in counts 2 to 7 of the indictment. And you were each actively seeking to acquire more. This included sharing recipes for Molotov cocktails and discussion of the need to save bottles for the making of them. You each acquired many weapons, including crossbows, swords, and knives. These include the stun gun, to which you, Marco Pitzettu, pleaded guilty, and the FGC-9, a 3D printed firearm, which you, Christopher Ringrose, were manufacturing. You knew that your conversations were outside of the norm, and at times expressed concern about others seeing them. You, Christopher Ringrose, were particularly concerned in this regard, and on a number of occasions set up group chats on forums which were difficult for others to access, saying on one occasion, and I quote, Does anyone know a safer, non-meta platform that we can move this ever spicier group chat to? The chat that day had been about making Molotov cocktails. You, Brogan Stewart, had said that day that you wanted to shoot someone. A year later, you again, Christopher Ringrose, set up a different group as you did not think others were as like-minded in your words. Your like minds on that day were discussing your interest, Mr. Ringrose, in the Iron Skull Division, Mr. Stewart, that you needed to cleanse England. Each of you sought in your evidence to persuade the jury that these were not your views and that you were engaging in ever edgier banter and a desire to shock others. The evidence overwhelmingly showed otherwise. All of the shared memes and shared violent thoughts were directed only at non-white races and Jewish people. There was no other theme. All were racist in nature, often violent and deeply offensive. Offensive though such thoughts are, the law permits you to hold them, even thoughts of violence. I make clear that I am not sentencing you for thoughts alone today. What is not permitted is turning those thoughts into the use or preparation for action involving serious violence against a person or serious damage to property or preparing so to do. You each crossed that line. There was a clear escalation in your behaviour, in what you were prepared to say and to share over the course of the period of the timeline, and by early 2024, in what you were prepared to do. It was at that time that you, Brogan Stewart, began to speak more urgently about the need for action. In other words, it was time for you to stop talking and to do something to advance your political cause. That was your idea. But you, Marco Pitzettu, and you, Christopher Ringrose, were more than willing to assist him in that regard. For that purpose, you, Brogan Stewart, set up a group entitled Einats 14. The name speaks volumes. Einats is an abbreviation of Einsatzgruppen, who were the death squads of the Third Reich, era deployed in the Nazi Party's implementation of what they termed as the final solution to the Jewish question. The number 14 bears a particular meaning in the extreme right wing. It refers to the 14 words which refer to the most popular white supremacist slogan in the world. On the 18th of December 2023, shortly before this group was set up, you, Brogan Stewart, had begun to communicate in a national socialist group on the internet with an individual who called himself Blackheart, whom you introduced via the internet to the others. Unbeknown to you, Blackheart was an undercover operative. During the course of the trial, you sought to blame Blackheart for your subsequent activities, saying that in reality he was the leader of the Einsatz group and that you acted and said as you did only because you wanted to impress him and said and did what you thought he wanted of you. I accept that you were, throughout the indictment period, an isolated individual with no friends and little in the way of healthy social interaction. I accept that you enjoyed the attention Blackheart seemed to give you, which you did not have from others. I reject, however, that you acted and said as you did only or even mainly because of him. Long before meeting Blackheart, you followed and regarded yourself as a soldier of Nazi ideology. You had a swastika flag on your wall and a Nazi symbol tattooed on your hand. You had studied and glorified the Nazi regime long before any connection or conversation with Blackheart. You knew the history of the Third Reich and how the regime was structured. You were in possession of replica items of clothing from the Nazi uniform, such as a Flecktarn shirt and a Stahlhelm helmet. In the weeks before you met Blackheart online, you were saying on the National Socialist Movement of the United Kingdom Telegram chat that, and I quote, "We should take note of SS and Einsatzgruppen methods. They were effective and sent a message," close quotes. that Nazis wanted what was best for white people and did all they could to save, in your words, and I stress not mine, us from Jewish scum. And then this, you said we must honour the men of the party and take up their struggle. Our children's future depend on it. You were already thinking of action. Einats 14 was styled as an armed military group for the purpose of taking action with weapons, explosives and incendiaries against perceived enemies of the Nazi cause. When asked what the overall goal was, you, Brogan Stewart, said you had taken inspiration from the SS. You adopted the name Führer and made Blackheart Obergruppenführer. You, I find, were in charge of the group. You drafted and posted the rules. They included a uniform styled on that of the Nazi regime and possession of personal weapons. Other recruits were sought. A vetting form was created for those who wished to join. It described Einats as an active group and asked the applicant to say who they hated most from a suggested list of non-white and Jewish peoples. You, Brogan Stewart, drafted a mission statement which included that it was the duty of members of the group, amongst other things, to, and I quote, target mosques, Islamic education centres, and other similar locations. This was posted onto the group chat. When asked whether you wanted to join a militant group or unit, both you, Marco Pitzettu, and you, Christopher Ringrose, showed interest. You, Christopher Ringrose, were told that Einats was a military unit and asked whether you were prepared to fight for your race. You replied by sending a GIF to the effect, "That is why I am here." You both completed the vetting form. You were willing members of the group. When asked whether you would be prepared to follow orders, you, Christopher Ringrose, said, and I quote, "Orders are orders. When I am in, I am in." You said that you considered yourself to be an asset in planning operations and 3D printing. A short time later, you, Marco Pitzettu, and you, Christopher Ringrose, were made the armourers of the group. When asked to be so, you, Pitzettu, said, "You already know that I'm in." You, Ringrose, said you would be honoured and excited to undertake such a role. And thereafter there was talk between you of where to get supplies and how to 3D print a firearm. The group was not just about documents and general statements of intent. You, Brogan Stewart, were in January 2024 looking for your first, and I quote, bit of action. You spoke of migrant hotels and needing something to strike fear, such as robbing migrants and making them feel unsafe. On the 30th of January 2024, you sent what was termed a mandatory order to the group that, and I quote, "We will be arranging a gathering to start attacks." You said a call to arms was necessary and that you needed to start planning ideas. You, Brogan Stewart, then identified your first target, an Islamic education centre in Leeds. You posted not just a photograph of it, but also a map upon which you drew a route of how to get there. You told Blackheart you could put the windows through and inquired whether he would prefer hanging around the area and ambushing someone. Then this: "It depends how far we are willing to go. It could be a beating with batons and bats, or something more serious." A group call was arranged to discuss this plan. In that call on the 5th of February, you, Brogan Stewart, said that the time for sitting aside and doing nothing was gone. You spoke of putting the windows of the education centre through or cruising the area and looking for victims. You, Marco Pitzettu, said that your vehicle could be used. You had access to some land, and arrangements were discussed to meet there for a training day, although you were all arrested before it happened. A terrorist attack was not imminent, nor do I find that, but for your arrest, you were ready to go. As things were left, you had not determined exactly what you were going to do, nor exactly when you were going to do it. Mercifully, your plans and preparations were being monitored and were ultimately thwarted by the authorities. For that reason, they did not advance, as far as I am satisfied they would otherwise have done. I do, however, find that a terrorist attack was likely in the not-too-distant future. Your preparations had reached the point of identifying the target, drawing a route of how to approach it, and discussions about how you were going to meet and get there. It is plain that at the very least, serious violence against property was planned. Violence against individuals was also discussed in the telephone call and before, and therefore clearly contemplated. I am satisfied that you each understood that the plan and preparations included damage to property and potentially serious violence. I have given careful consideration to whether there was a risk of death that was likely to be caused. At the point of your arrest and level of preparation for your first operation, you yourselves had not determined exactly what was going to happen. Whilst you had other weapons, explosives had been discussed but not yet made. Those weapons you had could, of course, have been used to inflict serious injury and death. But I cannot be sure that whilst there was a risk of death, it can properly be described as likely. You, Christopher Ringrose, did not participate in any of the group chats after the end of January or in the group call. You did not participate at all after Brogan Stewart had identified the Islamic Education Centre as a target. This time coincided with the birth of your second child. Your son was only a toddler, and you were to tell the group that your commitments at home were to take priority. You told the jury that you had checked out of the group at this time and no longer wanted to be part of it. I sentenced you on the basis that with your then family commitments, you were not able to or intending to get further involved with the group at that time. Nonetheless, you had played an active part in preparations up to that point. In particular, you had joined Einats 14 and encouraged others by so doing. You knew from the mission statement that mosques and education centres were to be targeted. You accepted the role of armourer and shared knowledge and information about explosives and 3D printing firearms, knowing that the group was now for action and that Brogan Stewart was looking for a target and planning a mission against migrants. You were searching for items to complete your firearm, I find by that stage with a terrorist purpose, as late as the 25th of January 2024. By the end of January, you, Brogan Stewart, were building connections with other extreme far-right groups and met with them, another indication that you were not acting under the direction of Blackheart. Your stated desire for action was not just words, nor confined to the Einats group. In early February, through connections made with other far-right individuals, you attended RAF Scampton, where it was thought illegal migrants were to be housed, although they were not then present, and groups of protesters were gathered. Whilst I accept that you were prone to exaggeration, I am sure from what you said about it both before and after that you were expecting and had engaged in violence there. It was something that you enjoyed and in which you revelled. In conversation with others you had met there, you spoke of violence against others of other races, your neo-Nazi uniform, and that war was coming. You further made contact with a man named Alec Yerbury, who is a far-right political activist, offering to provide, in your words, security from those in Einats 14 at rallies at which he spoke. This has a chilling resonance with the SS, who provided security for Hitler in the years before the war. You went to meet him and indeed other far-right individuals in Wakefield. Your individual association with those of the far right thus went beyond that of the others. I have approached the sentence of each of you by considering where in the relevant sentencing guideline on count 1 each of you falls by reason of your preparations for a terrorist attack in the near future. I do not consider it appropriate to uplift those sentences by reference to longer, more distant aims. I do, however, find that left unchecked, the escalation of your conduct of preparations would have continued. In my view, this, together with your mindset, is more appropriately considered on the assessment of dangerousness. The publications subject to the collection counts, that's counts 2 to 7, and the sharing of them are part of the preparations for an act of terrorism. I will reflect that conduct in the sentence imposed on count 1 and make the sentences upon those counts concurrent. In your case, Christopher Ringrose, I consider that the manufacturing of the lower receiver in count 8 for the FGC 9, although part of the preparation for an act of terrorism, is sufficiently serious to warrant a significant uplift to your sentence on count 1. In your case, Marco Pitzettu, I cannot be sure that your possession of the stun gun, found as it was in a poor state and with no charger, was with a terrorist purpose. I turn to consider each of you individually. Brogan Stewart, you are now 25 years of age. You have no previous convictions. As I have said, I am satisfied that you played a leading role in the offences for which you are to be sentenced. You were, I am sure, the driving force towards action rather than words. You set up the Einats group. You drafted the rules and the mission statement. You allotted roles to others and you identified the first target. I accept that in so doing you felt supported by Blackheart, the undercover operative, which may have emboldened you. But as I have already said, you were the one pressing ahead with the ideas. As the relevant sentencing guideline makes clear, your culpability and the question of harm is not affected by his involvement, and he must be assessed as if he was a genuine conspirator. The guidelines state that the involvement of Blackheart may result in a downward adjustment at step 2. I consider that only a small reduction is appropriate in this case for the reasons I have already given. I have read all of the psychiatric and psychological reports prepared upon you, which collectively speak of a long and complex history of mental health difficulties from a very young age. You undoubtedly had a very difficult childhood, much of which was spent in various placements in the care system. You have a neurodevelopmental disorder, autism, ASD, and now to a lesser extent ADHD, without intellectual impairment, oppositional and conduct disorder in childhood, and an emerging personality disorder. You have experienced hallucinations which are thought not to be psychotic in nature, but related to your ASD. There is limited evidence of responsiveness to treatment. I have had regard to the guideline for sentencing offenders with mental disorders or neurological impairments and considered whether your culpability is reduced by reason of these mental health difficulties. As the guideline makes clear, culpability will only be reduced if there is a significant connection between your disorder and your offending behaviour. According to Dr. Brown, a forensic psychiatrist who had the benefit of seeing you give evidence in the trial, as well as otherwise assessing you, it is unclear to what extent your complex mental health difficulties are directly linked to the commission of the offences, although in her view there is no evidence that psychotic symptoms played a role in them. In her view, there should be no assumption that ASD necessarily reduces culpability. She has said the fact that you have established neurodevelopmental difficulties may help to explain your offending behaviours, but your beliefs and behaviour cannot be explained by or attributed to your mental health diagnoses alone. Dr. Ruthenberg, a clinical psychologist and specialist in adult mental health conditions and neurodevelopmental disorders, has assessed you since your conviction. He also spoke of your significant underlying mental health issues. In his view, it would be difficult to reconcile the clarity and consistency of your messaging to others in the course of your offending with that underlying mental disorder. Your messages, in his view, had a clear logic and understanding to them. Instructions and plans were clear. However, he is of the view that your underlying difficulties may have predisposed you to some form of antisocial activity. Notwithstanding the influence of your mental health disorders on your functioning, in his view, you had a degree of understanding and knowledge that your actions were criminal. While significantly weakened by your underlying conditions, you chose to go ahead with your actions. Looking at the overall picture, it is clear that in part because of your difficult childhood, and in part because of your neurodevelopmental difficulties, you were at the material time friendless and isolated, with your social world restricted to your mother and online contacts. In the period of the timeline, you at times had talked about whether to take your own life. It is in that context, and it would seem in your feeling of powerlessness throughout your life, that the power of the Nazis appealed to you. I accept that to that extent, your disorder contributed to your offending. However, in my judgment, if it does reduce your culpability for that offending, it cannot be to any great extent. There is no evidence that your autistic spectrum disorder or other mental health difficulties impaired your ability to exercise appropriate judgment, make rational choices, or to understand the nature and consequences of your actions. You knew them only too well. Turning to the relevant guideline, I conclude that on count 1, you fall within category 3B of the sentencing guideline. You fall within culpability B by reason of your leading role in terrorist activity where preparations were advanced, and but for apprehension, the activity was likely to be carried out. I do not accept submissions made on your behalf that by the time of your arrest, the planned terrorist activity involving the Islamic Education Centre had dissipated. You were arrested only weeks after the meeting on the 5th of February, when discussion about it showed your clear intent. I have taken into account examples put before me by Miss Staffordshire King's Counsel in other cases that have come before the courts of activity which has the level of preparedness for categorisation B in the guidelines. However, each case must be judged on its own facts. I consider that the aims and duties of the Einats group, the identification of the target, and the planning of the route showed advanced preparations which, but for apprehension, would have been carried out. You fall within category 3 harm by reason of death being risked, but not likely in the planned activity to be caused, and the risk of widespread or serious damage to property. This categorisation affords a starting point of 12 years and a range of 8 to 16 years imprisonment. The offence was motivated by hostility based on the race of others, but I do not treat that as an aggravating factor, as it seems to me to be inherent in the terrorism offence itself, and I take care not to double count. Aggravating factors are, however, to be found in your repeated possession of extremist material, communication with other extremists, encouragement of others, and the use of telegram and encrypted communication to facilitate the offence and impede detection. In mitigation, I take into account that you have no previous convictions, your age and a degree of immaturity, your difficult background, and your mental health difficulties. I make a small reduction for the role of Blackheart, at least within your initial setting up of the Einats group. I further take into account all that your counsel has said on your behalf, including that you were, until your arrest in February 2024, when you were remanded into custody, the primary carer for your disabled mother. I accept and understand your desire to spend time with her, given her ill health. In relation to counts 2 and 3, the collecting information counts, I find that you had a terrorist connection and motivation, and these offences therefore fall within culpability category B. I consider that at the very least, the information involved instruction for specific terrorist activity intending to cause widespread or serious damage to property. Harm is therefore at category 2. I consider on the facts of this case at the higher end. This affords a starting point of 4 years and a range of 3 to 5 years imprisonment. Turning to the question of dangerousness, I have no hesitation in finding that you pose a significant risk of serious harm to members of the public by the commission of further offences, and that you are therefore dangerous. As the author of the pre-sentence report says, this is not simply a case of a naive and vulnerable person who spent a substantial amount of time on the internet and in so doing became fascinated or fixated with right-wing terrorism. You are, in my view, deeply entrenched in extreme right-wing ideology. You sought to recruit and groom others and to organise those individuals into action rather than talking. The description of the author of the pre-sentence report of you pushing any facts that challenge your beliefs to one side is of concern. You are described as lacking empathy and seeking to connect with others in planning violence and fantasizing about inflicting it on others. In her view, you enjoyed the self-conferred status of leader of the group. You have a deeply entrenched sense of over-entitlement combined with low self-esteem and low confidence. The author considers that the risk you posed to the public was imminent, and nothing has changed since that time, apart from your incarceration and time to ruminate on your own victimization. Dr. Ruthenberg observes that Hitler, Nazism, and National Socialism centering on fantasies of power and dominance has served as the single source of your obsessional idealization and identification. In his view, you also harbour unresolved grudges against society, rooted in experienced rejection and ostracism, further compounding the risk of targeted or retaliatory aggression. Unresolved and repressed trauma may also pose a further uncertain risk. Taken together, these features, in his view, represent a significant and multifaceted risk profile requiring robust risk management. Dr. Brown says that the relationship between your mental disorder and risk is difficult to unpick. In her view, you lack many protective factors and present with a large number of risk factors for future violence. The combination of your neurodevelopmental disorders with conduct disorder and emerging personality disorder presents a particularly challenging risk profile, as well as therapeutic challenges. Together, these opinions support my own conclusion from seeing you give evidence over many days and from what you wrote on the timeline that you are dangerous within the meaning of Section 279 of the Sentencing Act 2020. I must therefore first consider whether the seriousness of count 1 and the other offences justify a life sentence. Whilst I have concluded that such a sentence is not necessary in your case. Whilst the offending is undoubtedly serious, at the point of your arrest you had not committed any act of terrorism. Your preparations had not yet reached the risking of many lives. You hold entrenched views, and there is no reliable estimate of how long you will remain a danger. You are, however, still young, and I consider that a long determinate period, together with a lengthy extended licence, will protect the public. I must next consider whether a serious terrorism sentence should be passed in your case. This would be the appropriate sentence if the risk of multiple deaths condition is met. Section 268B, subsection 3 of the Sentencing Act 2020 states that this condition is met if I conclude that the offences were very likely to result in or contribute to, whether directly or indirectly, the deaths of at least 2 people as a result of an act of terrorism. I have given anxious consideration to this question. I have already determined that there was a risk of death in your first operation, but I am unable to be sure that the deaths of at least 2 people were very likely overall. In those circumstances, the multiple deaths condition is not met, and a serious terrorism sentence is not open to me. That applies to all defendants in this case. I have concluded in all of these circumstances that in your case, Brogan Stewart, an extended sentence is both necessary and appropriate. Marco Pitzettu, you are now aged 25 years. You have no previous convictions recorded against you. Prior to your arrest, you had been in constant employment and were living at home with your parents. You have had a stable and loving upbringing. It is not clear in those circumstances why and how you developed a far right-wing mindset. You have a strong interest in video games, and it seems that drove you to an online world where you met your co-accused and discovered others with similar mindsets and views of the world. I also note the report of Dr. Wood, a psychologist, that you are at the high-functioning end of the autistic spectrum. Whilst I accept that this caused you some difficulty in making friends, you were not isolated in the way that Brogan Stewart was. I saw you give evidence. There is no suggestion that you could not exercise appropriate judgment, make rational choices, or understand the nature and consequences of your actions. I do not find your culpability reduced by reason of any neurodevelopmental disorder. As the timeline shows, you demonstrated hatred towards non-white and Jewish people, agreed with ideas of white supremacy, and glorified in mass killings. You shared recordings of them with the group. You were also interested in making things. That could have been a positive attribute, were it not directed towards Molotov cocktails and weaponry for use in the cause. When Brogan Stewart asked if you would be interested in joining a National Socialist group, you inquired whether you would be permitted to do so, as you are half Italian, but you said that if it would help to get you in, you could weld, bladesmith. On the vetting form for Einats 14, you said you could bring to the group your mechanical and engineering-based mindset so you could make something useful. It is no coincidence that you were made the armourer of the group, after which you sought to obtain the know-how and items you needed, particularly for firearms. As it happened, you had not, by the time of your arrest, come close to making them. You were the one, however, who shared most of the publications on the making of explosives. Further, you offered the use of land to which you had access for training and the use of your vehicle to drive others to any attack. This was of particular significance in the planning of the attack on the Islamic Education Centre, for which you offered to drive others. When Brogan Stewart first identified that target, you were immediately searching the internet for a similar centre in Derby, where you lived. I do not consider that you were at the head of any group, nor were you coming up with ideas for targets. I do, however, consider that you were eager to be involved to any extent asked of you and to play any part that would be useful in an attack. Your involvement in the discussions online were encouraging to others, and as such, I consider that you played a significant role in the offending. On count 1, I place your offending within category 3C of the relevant sentencing guideline. You fall within category C culpability as you played a significant role where preparations were advanced, and but for apprehension, the activity was likely to be carried out. That affords a starting point of 8 years and a range of between 6 to 10 years imprisonment. There are the same aggravating factors as I found for Brogan Stewart. In mitigation, I take into account your age and the fact you are of previous good character. I further take into account all that has been said on your behalf, in particular, first, that you did not actually make any explosive or firearm device. You were seeking the know-how, but had not got that far. Second, it is not necessary to have explosives or firearms to commit a terrorist attack. You had weapons which would easily be used to do so. I accept, however, that you had not, by the time of your arrest, used them or allowed anyone else to do so. And third, there are clearly positive aspects to your character. You have always been employed and clearly worked hard. You have engaged well in custody and retained a positive outlook. I place the collecting information counts, that's 4 and 5, in category 2B for the same reasons as for Brogan Stewart. The offence in count 9, possession of a prohibited weapon, falls within category 3B of the relevant guideline. The offence is not subject to the statutory minimum sentence. I find that you acquired the stun gun with the intention of using it for a criminal purpose, but at the time of your arrest, you having lost the charger, it was incapable of use. You pleaded guilty to this offence. The prosecution were notified 2 days after your initial not guilty plea that it had been entered in error. I accordingly afford you 25% credit for that plea. I turn to the question of dangerousness in your case. I conclude that you do pose a significant risk of causing serious harm to members of the public by the commission of further offences. I agree with the author of the pre-sentence report that your offending demonstrates a deep commitment to the extreme right-wing ideology which you and the others were actively pursuing. This had escalated from online chat about your ideologies to audio calls and identifying specific locations to target. Your intentions were becoming increasingly serious. If your plan had come to fruition, significant harm could have resulted. I see nothing in the report or in any other matter that's been put before me to suggest that your views have changed. You have certainly not taken any underlying responsibility for your behaviour. I do not conclude that a life sentence is necessary in your case. However, an extended sentence is necessary and appropriate. Christopher Ringrose, you are now aged 35 years. You have one previous conviction for possession of cannabis. I treat you as a man of good character. At the time of the offending, you were married with a child. Your daughter was born days before your arrest. You were in full employment. Your priority and time should have been with them. Having seen you give evidence, I agree with the author of the pre-sentence report that your level of interest and involvement with the group in this case was a priority to you and was not just for internet banter or friendship as you claimed. I also agree with her that you have entrenched racist and violent views. You used the groups to express those views and incited others to do so. You actively contributed to online discussion and participated in planning with a view to committing acts of terrorism. On your application to join Einats, you described yourself as being useful in planning operations. On the day you accepted the role of armourer for the Einats 14 group, describing yourself as honoured and excited, you were recommending a supplier for explosion-proof hydraulic piping. You were sharing information about firearms, explosives, and 3D printing, I find with a view to making firearms, with the others, and so assisting them up to the end of January 2024. Perhaps most concerningly, you were endeavouring to 3D print a firearm yourself. You had printed the lower receiver for such, for which I am to sentence you. You were trying to source the metal tubing and other items necessary for the completion of the firearm, right up to the end of January 2024. I do not accept your account at trial that this was for display purposes only. Your collection of videos and documents detailing how to make this a working firearm show that was your intent. You did not need to make a working firearm to display. Your intent, I find, was certainly by 2024 to have it for use in terrorist activity. The offence therefore has a terrorist connection, which is an aggravating factor. There was ample opportunity to remove yourself from the group, but for most of the time with which the jury were concerned, you chose to involve yourself with like-minded people whose hatred for others was clear from the outset. As with the others, you had a willingness to resort to extreme violence to achieve the desired shared outcome. As I have already said, I accept that part of the reason for your failure to attend the group call on the 5th of February concerning the first operation was that you were not committed to it at that time when the demands of your family were greater. I therefore sentence you on the basis that right at the very end, for that reason, you were showing signs of voluntarily desisting. I accept that there is no evidence that you were assisting or knew about the specific plan involving the Islamic Education Centre in Leeds. However, you were providing encouragement and assistance in the sharing of information about weaponry not long before that. It is also clear from the pre-sentence report that any voluntary desistance is not based in you giving up your extreme views. Those you still have. I consider it much more likely that you were more concerned with your family at the time that your wife gave birth to your daughter. I have considered carefully where on count 1 you fall within the guideline. As I have said, there is no evidence that you were aware of the specific plan to target the Islamic Education Centre in Leeds. However, you had with enthusiasm agreed to join the Einats group, saying that you were there to fight for your race. You completed the vetting form, saying when asked whether you were prepared to follow orders, when I am in, I am in. You knew that one of the duties of members of the group set out in the mission statement was to target mosques, Islamic education centres, and other similar locations. You said you could bring to the group your knowledge of mechanics, ability to plan operations, and 3D printing when you had time. You said you were honoured and excited to accept the post of armourer. Knowing the aims of the group, you shared your knowledge of explosives, 3D firearms, and where to get explosive-proof tubing for them. You suggested to Brogan Stewart that you could set up a prepping group as a way to screen potential recruits for Einats. In January 2024, you again shared material such as a video of a woman being beaten up by foreign people, Brenton Tarrant's manifesto, and other material, knowing, I find, that it would whip up feeling and motivate people within the group. Against that background, I find that you played a significant role in terrorist activity where the preparations were advanced and but for apprehension the activity was likely to be carried out. This places your offending within Category 3C of the guideline. The fact that you were unaware of and played no part in the suggested targeting of the Leeds Islamic Education Centre and had desisted a short time before discussions in that regard warrants, in my view, a small reduction of the notional sentence. The same aggravating factors apply as for the other defendants. In mitigation, I take into account your lack of previous convictions and all that your counsel has said on your behalf. In particular, I accept that you did not actually involve yourself in any incident of violence or attend locations where such may have occurred. You were, however, encouraging and assisting others, knowing that was planned. I take into account the impact of your offending on your family, on your children, and on your ex-wife. That, of course, is as a result of your own decisions and actions. I have read and taken into account all the character references submitted on your behalf. I accept that they show a different and more positive side to your character. It is of note, however, that none of those individuals knew of your activities and interests online. I have read and taken into account, to the extent that I can, the context of the letter that you have written to me. It is to your credit that you have sought to use your time in custody productively in taking courses and have undertaken work as a mentor and listener within the prison. The collecting information counts 5 and 6 are within category 2B for the same reason as for your co-accused. Count 8, in fact I think it's 6 and 7 for you, count 6 and 7, the collection of terrorist information. Count 8 concerns the manufacturing of the lower receiver. I place this into category 3A of the relevant guideline. It falls within culpability A as there was significant planning to its manufacture by the acquisition of the instructions, the printer, and components required to manufacture the firearm. It falls into harm category 3 as it was a small-scale enterprise. This offence of itself has a starting point of 10 years with a range of 8 to 14 years custody. I recognise that the receiver was but a component and that the firearm had not yet been completed. This would warrant a small reduction to any term imposed. However, as I have said, the offence has a terrorist connection, which is an aggravating factor. You had also not manufactured this component part in isolation, but were continuing to look at ways of completing the working firearm. The offence, in my view, requires a significant uplift to the sentence on count 1. I turn to the question of dangerousness in your case. I agree with the author of the pre-sentence report that for the reasons she gives, you are dangerous within the meaning of the Sentencing Act. The offences demonstrate a conscious decision to jeopardise the immediate and lasting well-being of innocent people. Significant protective factors such as employment and family failed to prevent them, and your views currently remain unchanged. I do not consider a life sentence to be necessary in your case. An extended sentence will meet the public protection concerns. I turn to sentence. I consider that in the case of each of you, a serious crime prevention order is necessary. There are reasonable grounds to believe in the case of each of you that you will be involved in further conduct, falling within the definition of serious crime for the reasons set out by the prosecution. I have already said that I am satisfied that you each continue to have an extreme right-wing mindset. All of your interactions were online. Restrictions are necessary on your individual use of communications, electronic storage devices, access to the dark web, notification of various usernames, internet access, instant messaging, and online cloud storage. This is to circumscribe how you each operate online and through communications. It is also to prevent you coming together upon release to form future like relationships. There is a need, given the weapons you each accumulated, to restrict your ability to possess crossbows and air weapons, amongst others. The fact that I have found each of you dangerous does not obviate the need for this restriction. The test is met for each of you, and the orders will last for 5 years after release. If you fail to comply with the order, you will be committing an offence for which you could go to prison. The surcharge, if it applies, must be drawn up for each of you in the appropriate amount. Brogan Stewart, stand up. On count 1, I sentence you to an extended sentence of 19 years imprisonment to be comprised of a custodial term of 11 years and an extended licence period of 8 years. In coming to the custodial term, I have increased the starting point within the guideline from 12 to 13 years to reflect aggravating factors and the totality of your offending on all counts. I have reduced that to 11 years to reflect a small reduction for the role of the undercover operative, to take account of your age, difficult childhood and mental health issues, which I accept played a small part in your offending. The sentence on each of counts 2 and 3 is 5 years imprisonment concurrent. The total sentence is therefore an extended sentence of 19 years imprisonment made up in the way I have set out. You will be required to comply with notification requirements for 30 years. Sit down. Marco Pitzettu, stand up. On count 1, I sentence you to an extended sentence of 13 years imprisonment to be comprised of a custodial term of 8 years and an extended licence period of 5 years. In coming to the custodial term, I have increased the starting point from 8 years to 9 years to reflect the aggravating factors and the totality of your offending. I have applied a downward adjustment of 1 year to reflect your mitigation, coming back to the custodial term of 8 years. On each of counts 4 and 5, I sentence you to 5 years imprisonment concurrent with each other and with the sentence imposed on count 1. On count 9, applying 25% credit for your guilty plea, I sentence you to 4.5 months imprisonment concurrent. You will be subject to the notification requirements for 30 years. Sit down. Christopher Ringrose, stand up. On count 1, I sentence you to an extended sentence of 15 years imprisonment, comprising a custodial term of 10 years and an extended licence period of 5 years. I have come to the custodial term in the following way. I have reached a notional sentence of 7 years imprisonment to take into account that you were not party to the planned attack on the Leeds Islamic Education Centre. I have increased that by 12 months to reflect the aggravating factors and the offences in counts 6 and 7. I have increased it by a further 3 years to reflect the firearms offence in count 8. I have reduced that term significantly by reason of totality. I have then applied a downward adjustment of 12 months to reflect your mitigation. On each of counts 6 and 7, the sentence is one of 5 years imprisonment concurrent with each other and the sentence on count 1. On count 8, I sentence you as an offender of particular concern to a sentence of 4 years imprisonment comprising a 3-year custodial term and a 1-year extended licence period concurrent to the other terms imposed. You will be subject to notification requirements for a period of 30 years. You may all go down.